questions, comments, observations, thoughts? Pleasant out here. We should be meeting in States Plaza. Or down by the lake, even preferable. Now the lake will be cold. The lake is still 30
All my
degrees.
notes would blow away.
Huh?
All my notes would blow away.
Would blow away, right? No, but you see,
That's a lot of work.
no, but the notes might blow away, but it would be all in your head, right? So you'd be in great shape still. Yeah. Okay, I'd like to finish these two cases and my concluding lecture on the rise of Jim Crow, so that we can have our exam on Thursday. But I've been telling you for some time now to prepare for either Thursday or next Tuesday. It looks now that we shall go on Thursday. So let's go with Berea College. On October 8th, 1904, the grand jury in Madison County, Kentucky, presented an indictment against Berea College. And the indictment read in part: the said Berea College, being a corporation, and note the crucial term here, corporation, being a corporation duly incorporated under the laws of the state of Kentucky, and owning, maintaining, and operating a college, school, and institution of learning, known as Berea College, located in the town of Berea, Madison County, Kentucky, did unlawfully and willfully permit and receive both white and Negro students. Let me reconstruct. Receive both the white and Negro races as pupils for instruction in said college, school, and institution of learning. Now that indictment was returned on the Kentucky statutes of March 22, 1904. And remember, I read them for you. But just to refresh the memory, Section 1 and Section 1 I'm going to read again for you because it's so important. That it shall be unlawful for any person, corporation, or association of persons to maintain or operate any college, school, or institution where persons of the white and Negro races are received as pupils for instruction. And any person or corporation who shall operate or maintain any such college, school, or institution shall be fined $1,000. And any person or corporation who may be convicted of violating the provisions of this act shall be fined $100 for each day they may operate said school, college, institution, after, of course, conviction. Section 2 prohibits any instructor to teach in any school, college, institution that has, of course, then both black and white pupils. Section 3, that it shall be unlawful for any white person to attend any school or institution. And the crucial term here again, any school or institution, like UWM. Or like the UW system, because the UW system is an institution. Right? It's an institution with 11 four-year institutions. Well, it has 13 actually. 11 comprehensives, what I call it comprehensives. 2 doctoral institutions, right? 13, plus then the 13 colleges, and then extension. That make up the institution known as the UW system. So keep that in mind. So for any white student and a black student who attend the same institution, and any person so offending shall be fined $50 for each day he attends such institution or school, and so on. Well, now listen to section 4. Nothing in this act shall be construed to prevent any private school, college, or institution of learning from maintaining a separate and distinct branch thereof in a different locality, not less than 25 miles distance, for the education exclusively of one race or color. Well, Berea College was chartered in 1854. It's a Quaker school, and it taught both black students and white students. Its purpose in its original articles of incorporation was fundamentally as follows. It said, its object is the education of all persons, who may attend its institution of learning at Berea. And its fundamental purpose is to promote the cause of Christ. So it's a religious. And it taught both black students and white students. Quakers were one of the early supporters of the abolition of the institution of slavery. Well, in 1891, Kentucky adopts a new constitution, but you know, the early 90s is the time when new state constitutions are being adopted, right? Jim Crow is spreading its wings. And it's under this new constitution of 1891 that the new statute of 1904, of course, stands. Well, the state brings then suit against Kentucky in regard to teaching black students, white students, in the same institution. But what Kentucky, in regard to section 4, right, of the statute had done was to establish a separate branch to meet the 25-mile distance where black students were received as pupils. But then you see, section 4 does what? Runs afoul of section 1, which says the same institution may not teach both black students and white students. Well, the institution is indicted. It asks that the indictment be quashed. That petition is denied. The case goes to trial. It is found guilty, fined $1,000. And it appeals to the State Court of Appeals, and the State Court of Appeals affirms the decision of the trial court. The case then gets to the Supreme Court. What does the Supreme Court decide? The decision of the court, and then we'll just read for you some of the sections as I always do. It says, look, Berea College is a private institution, true. Unlike the UW system, which is a public institution. But notwithstanding that Berea College is a private institution, it operates under a charter granted by the state. So then the state, in granting that charter, has, says the state, the authority under the Constitution, both of the state and of the United States, to regulate the affairs of the institution, right? So that the institution acts in a manner consistent with the charter that it is granted, a charter consistent then with what? State law. So then, though Berea College has this branch 25 miles hence, it still is teaching pupils of both races in the same institution in violation of section 1 of the statute of 1904. But then an interesting point comes into play. interesting point comes into play, which is, and my brain has short-circuited, my computer has short-circuited. Now, what is the interesting point? See, that's what happens when you go to walking. See, I don't have all these things written out in notes. They're in my head. And if my brain short circuits. Someone refresh my memory, as Johnny Cochran was fond of saying. What's the point I made immediately before?
They were in violation of section 1,
Right?
even though they were in compliance with section 4.
Right.
And the interesting point was,
It's completely short circuit. Anyway, I'll have to do a reconstruction. Section 1 clearly prohibits, right, black students and white students being taught in the same institution. Section 4 would appear to permit them being taught in the same institution, though of course in different places. So they would be now being taught in the same institution in different places at the same time. Or of course you could, Berea College could switch it, right? They could have all the white students now 25 miles in the place where they had the black students, and now the black students where the white students are. That's not the point I wanted to make. In any case, the critical point here is that the Supreme Court, okay, it's coming back to me now. The Supreme Court says, look, is it the case, right, that if one has a statute with 5 sections, as this particular, I didn't read section 5 to you, but section 5 of the statute of 1904 says, this act shall not take effect or be in operation before the 5th day of July 1904. If it is the case, right, that one provision of an act with a number of provisions is constitutionally inferred, does that render the entire act constitutionally inferred? Right? So the whole act is unconstitutional. Or might a given section of an act be unconstitutional, but the other sections remain constitutionally firm? You with me? So that the whole act itself is not unconstitutional. And the Kentucky Court of Appeals says in effect, not says in effect, says that Section 5 was unduly oppressive in regard to the police power of the state in regulating its affairs. And so that whatever may be the problems between sections 1, not 5, sorry, section 4, the 25 miles distance, whatever the problems between 1 and 4 might be, 1 stands as constitutionally free. In other words, Berea College may not teach both black students and white students.